And so welcome everybody to our very last webinar of the academic year. So it's not the end of the year yet, it's just the academic year. So before the summer starts. And I am super excited, as you can imagine, with the World Cup and then the red card and all of that. And some people not knowing what a red card is, but issuing a red card. And so we are going to come back to where dealing with sports. And today we're engaging with the field of play, what it is, where we are at, and possibly we may get some insights into thoughts on where we may want to be and where the World Cup, the various things that have been thrown at us from the World Cup. So I have two super excitable for me individuals who will deal with this session. And I'm going to introduce our moderator, hand over to her, and she would do us the honors. They would, herself and Professor Calo would speak and engage and do their thing. And we've said if they need additional time, because this is an important topic, they can have additional time. The chat will be open as usual. Please let us know. As a matter of fact, if you can all just put your name and where you're joining us from in the chat. I think our speaker moderator would love to know. We know that the Commonwealth Games is happening now. Hopefully, our moderator will not be required, but she's on call and she would explain what that means for disputes arising out of the Commonwealth Games. So we're hoping that nobody will call her until we finish the webinar. When we finish, they can call her and then she will go and sort them out. And so, our moderator. So our moderator is Miss Njeri Onyango. She's a senior counsel out of Kenya. She sits as an arbitrator. She's also a certified mediator. She describes herself as an internationally recognized sports law practitioner. But that's because she's big on CAF. And we'll come to that. So that's the Africa football regional grouping. And so she has over 3 decades of experience in dispute resolution and sports governance. She's big on sports. I'm really very excited. She has her own practice and she's held loads of responsibilities, and she's served on numerous national and international organizations. She is the vice president, I said, of CAF. CAF is the French acronym for the Confederation of African Football. She's the vice president of the disciplinary board. So she might be happy to answer the question on Africa Cup of Nations. I don't know. I'm just suggesting. But she's the vice president. But that's a live. It's gone on appeal to CAS. She's the vice president of CAF Disciplinary Board. And anti-doping, she is the chairperson of WADA's Continental Resort Management for Africa. She would explain what that means. And she's part of Sports Resolution UK. So she's a member of various sports organizations. But for me, I think 2 really important ones is the World Aquatics Disciplinary Panel, because I love the swimming competition and aquatics and all the other things they do in there. And she's also part of the Kenya Sports Dispute Tribunal. So she's big, she's huge in the sports world, and she knows what she's talking about. She used to be the vice president of tennis for Kenya and a member of the National Olympic Committee of Kenya. She's she's doing all the things that I would like to do when I grow up in this area of the law. And so I would hand over to Njeri. Njeri, thank you so very much for accepting our invitation. Thank you for joining us this evening. So I'll hand over to you and to Zachary.
Thank you very much, Emilia. Emilia, you have outdone yourself in trying to describe me. I'm just me. I'm just Njeri, the one who smokes spots. So I'll leave it at that. Thank you very much. Uh, Good morning. I hope there are people who are joining us when it's morning. Good afternoon. Good evening. I'm sure those of us who are in the East and Central Africa region, it's evening. For Emilia and the rest, maybe it's still early evening. For us, it's sleeping evening. And afternoon, I guess, for you, Zachary.
Indeed.
So thank you for choosing to join us under whatever circumstances and wherever you are at. Let me start with a disclaimer. The topic for today was discussed before the red card in the World Cup. So please don't castigate us. It was mooted long ago by whites and first seeing Emilia long before the World Cup. Thank you, Emilia, for convening and thinking through this very good topic, and for you and your team for coming up with a very able speaker today, whom I shall introduce later. It will be a brainstormer. I want to assure you that. When you think about it, field of play, there are three words that may sound very innocuous until you start peeling the onion, as they say. Then the sting to your eye really comes through. Think about it in terms of the various fields that there can be: the water, the sea, or the river, for those who do the kayaking. For those of us who are in volleyball or tennis, there's a court. For those of you who are football lovers, there's a whole field. For those who are cyclists, there's the road and the hills and then there's those who do the snow skiing and all that. All those are our fields, depending on what sport you are at. And may I not forget swimming, lest I get castigated by my former people in the swimming world. Now, really, what is this, the field of play, and how small, whether it is the measured field by volleyball standards or tennis standards, or how far can we extend it outside that field, outside whether you call the person a referee, an umpire, or whatever the decision-making rule enforcement personnel on that field. Those are the questions we need to throw at Zachary today, for him to tell us how far we can, what is the limit? Is there an absolute? How far can we extend the field of play? What have been the trends? What are the consistencies or inconsistencies in interpreting field of play occurrences? And generally to talk to us about what would be his experiences in interpreting the field of play applicable rules. Emilia is very uncanny, and really she put me in a bind, because Zachary is the kind, from his introduction, you'll see, that has represented the opposite side of whether it's the player or the federation, and against the me's or the people like myself who sit in decision making and who are very fond of extending their territory. So he'll tell us whether my kind have been consistent or inconsistent in keeping to the field of play, and whether we have breached or fallen in danger of breaching and extending the field of play too much. Ladies and gentlemen, we have a real eminent person to speak about it, and not just to speak about it from reading from books, but from experience. Allow me, therefore, to introduce our evening speaker, Zachary Calo. Zachary, please wave at our members. Zachary is a professor of law, an arbitrator, a mediator, an attorney who has worked, whose work has focused on sports law and international dispute resolution. He is a professor of law at Touro University, Jacob D. Fuchsberg Law Center in New York City. He has previously served at the faculty at Hamid bin Khalifa University in Doha, Qatar. He is an author or editor of more than 80 scholarly articles and 3 books. At the end of it, Zachary, please post them so that our people may be bound to maybe purchase 1 or 2. This includes a forthcoming commentary on the Court of Arbitration for Sports, which will be published by the Cambridge University Press. He maintains an active international practice as counsel and neutral, regularly representing athletes before the Court of Arbitration for Sports, CAS, and other tribunals. Fortunately, not before me yet, but I do hope to find him there soon. He serves as the OF counsel and the head of U.S. legal practice at the Shellstraat Aquin Law in Amsterdam, an OF counsel at the Caribbean Haggerty in Abu Dhabi and Washington, D.C., and as a founding partner and international mediator with the Gulf Mediation. He holds a JD from the University of Virginia School of Law, a PhD from the University of Pennsylvania, and an LLM in dispute resolution from the Strauss Institute Papadine Caruso School of Law. That is the caliber of person speaking to us this evening. So please, ladies and gentlemen, because of time and having spoken to Zachary, I know he has a lot to say. Allow me to invite Zachary to please speak to us. What we will do, we will give Zachary about 25, maybe 30 minutes to say, because I know he has a lot to speak on. And then we will go to a Q&A, and thereafter, hopefully hand back to Emilia for a close-up. So Zachary, please welcome those of us who come from Kenya, and I've seen a few on, we say Karibu. Thank you very much, and welcome, speak to us.
Indeed. Thank you for that very kind introduction, Njeri. And good morning. I saw a couple of friends from the West Coast in the US, and good afternoon and good evening to those elsewhere. I should thank you, Njeri, as well for the plug of my books. I think my last royalty check from Cambridge was about 65 cents. So every sale would be very welcomed. Let me just, before I get started, just a couple of words of thanks. First to Emilia, who very kindly offered this opportunity to speak today. We had the chance to meet a few months ago for the first time in Mexico. Really enjoyed her company and am very grateful to be here today. And she also was being far too modest in describing herself. She is, among other things, a new member of the CAS panel, and I want to extend my congratulations to her on that appointment. And I think I saw Hannah somewhere, although she's disappeared from my screen, but Hannah was very helpful in handling all of the logistics, which I appreciated. And to you, Njeri, we had a lovely chat yesterday. It's very nice to get to know you. And you are, as Emilia said, big, or maybe as Donald Trump would say, huge. And I appreciate your taking time away from your work and from the Commonwealth Games to be with us today. So we're going to talk about field of play, and as was mentioned, we were not aware of what was going to happen when we chose this topic a few months ago. What was in the news then, and I think was partially what sparked Emilia's thought about this as a potential topic, was the controversy involving the AFCON final, which we'll certainly talk about. But of course, it is now once again in the news because of our president, who, although not knowing what a red card is, seems to have very strong opinions about how they should be allocated. So it is a timely topic. and I think an ever timely one. What I want to do today, because I'm spending some time in the research side of my life working on this topic, which had been of interest to me because of some counsel work I had done, and in particular a case which I will mention. And so I've begun the process of reading through a number of the cases over the past 8 or 10 years and trying to make sense of what is happening. And so what I'd like to do today is run through a few of what I think are the interesting cases that provide some data points in the development of this quite important doctrine. So I'm sure most of you are familiar with what the doctrine is, so I don't want to spend too much time getting into the particulars of it, but I should say just a few things to situate our conversation. First of all, this is not a new issue. I mean, long before there was a court of arbitration for sport, domestic courts were addressing the question of should they intervene in sporting decisions. And it became quite clear over time that the answer to that question was no, that courts do not have the competence or even the authority to substitute their judgment about matters pertaining to the field of play, judgments and decisions made by referees and officials, and that they should be insulated to some extent from review. And this is a very well-established principle, more than 100 years of jurisprudence. And so on one hand, you could certainly posit that few doctrines in sport law are more settled than this, right? The principle that decisions made by referees, judges, etc., in the course of play should be immune from review. And that needs to be our starting point, right? That this doctrine in most respects needs little comment. The principle is established. And yet, right? And yet, field of play keeps reemerging, right? It is constantly in the news, whether that be Olympic judging controversies, retrospective sanctions, post-competition adjudications. 2 weeks ago at the World Cup, the question of field of play endures. And so one question I want us to think about, the central question I want us to think about is why? Why is this doctrine so deeply established, both in what it stands for and also the logic behind it? The notion of finality, the idea of competence, the need for preserving sport autonomy, all of these concepts which are unquestioned. And yet we still continue to have a steady flow of cases, some of them of a very high profile and controversial nature, that force us to return again and again to what the field of play means and how it is to be applied. And so, as I've tried to make sense of what is happening, here's the, call it a thesis or perhaps just a hypothesis that we might explore together, is something like this, that sport is increasingly governed by technological, procedural, institutional systems that are increasingly blurring the boundaries between what is a sporting judgment and what is a legal rule. And the most significant field of play controversies over the past, let's say, decade or so, don't concern review of officiating decisions, right? I mean, that matter is largely closed off, but rather they concern let's call it the decision-making architecture through which these decisions are produced. Right? So the traditional doctrine, a century of this doctrine, rested on a fairly straightforward arrangement. A referee, a judge, an official would observe an event, would apply the rules of the game, would make a real-time judgment. And so the justifications made sense within that model, right? There was a clear and a compelling rationale for the principle of restraint. Contemporary disputes, by contrast, often arise not from a simple complaint that a referee got the call wrong, but rather that the processes in place that allow for ever more complex and variegated decision-making processes call out for a question of, does the field of play extend to them? And if so, when? So in particular, what I think, again, to kind of state what I think is the central point of tension, it's between what is a field of play judgment deserving of deference, what is a sporting decision, and what is a legal rule governing a process or a protocol or a review mechanism. And this leads us in some ways to a quite curious paradox that as sport governing bodies have created these procedures in an attempt to create more clear, fair rulemaking, they've created the possibility of more disputes. Right? So they've tried to solve the problem of unfair or wrongful judgments by creating these additional processes, but in turn, this has generated new opportunities to call into question when does the field of play doctrine apply. Okay, so that's kind of the context that I want to put forward as the background for our explanation. Now what I want to do is look at 5 cases, and I'm going to have to do this quickly, so it necessarily will be a little bit of a whirlwind tour. This will certainly not be a systematic review of recent jurisprudence. And as I mentioned at the outset, some of these cases are very well known. Others you've certainly never heard of and probably never will outside of this context. But all of them in one way or another touch on what I think is an important data point in trying to diagnose what is happening with the field of play doctrine. So let's walk through these. The first one I want to mention is from the 2024 Paris Olympic Games, and it involved a canoeist by the name of Benjamin Savsek from Slovenia. So it was Savsek versus the International Canoe Federation. The background is quite simple, and by most measures, it's a rather mundane case. Savsek was assessed a 50-second penalty on the grounds that he failed to properly navigate one of the gates on the course. And this had the effect of eliminating him from the competition, whereas he had won the gold medal in the 2020 Olympics. Savsek challenged this result before the ad hoc tribunal of the CAS on the grounds that the chief judge who made this decision had acted in an arbitrary fashion. Now, a little bit of background here is important. The way the rulemaking mechanism is set up for judging in the canoe finals of the Olympic Games is that there is a judge and a video judge for each of the gates. And if they fail to agree on an evaluation, the matter goes to the chief judge who has exclusive authority to render a final judgment. Okay? And that's what happened here. Now, Savsek's claim was that this was arbitrary. It was lacking in adequate grounding, mainly because there was not a written opinion offered. But all of this failed to persuade the sole arbitrator, who I think quite appropriately concluded that the authority of the chief judge clearly set out in the rules of the federation, provided that the judge has the authority under these conditions to render a decision, and that there is no obligation to provide a written rationale. So it's a fairly straightforward case, and I don't think, indeed, on its own terms, is particularly controversial. But it does raise some interesting questions because it allows us to begin to see what is happening in the field of play context. So one might be led to think that when you have a multi-tier, complex, layered decision-making process like this, where you have judges on the ground, judges reviewing by video, and then a chief judge with the authority to make a final decision, that this might become more susceptible to some kind of legal scrutiny, right? It starts to look more and more like an administrative process as opposed to what we think of as the classic field of play in which a judgment is made in real time. But what the arbitrator impliedly proposed in the award is that the entire process, going from decisions made in the moment all the way to the chief judge reviewing video and making a final decision, this entire process is part of the field of play. They are all part of determining what should be the appropriate sporting decision. Okay, so the uses of technology, the creation of these multi-tiered processes do not in and of themselves transform that primal sporting judgment, which we associate with the classic field of play as being that instant judgment by an official. They don't transform it into something else, and therefore it does not make it reviewable. Okay, so this decision, again, quite simple, I don't think particularly controversial, begins to introduce this framework of how the CAS has thought about decision-making processes that go beyond the classic model. Okay, so in light of SovSec, if we want to kind of extract a holding from SovSec, it might simply be that the field of play doctrine is becoming less concerned with identifying a decision maker and more concerned with diagnosing what function a process is performing. And if that process is fundamentally focused on determining a sporting judgment, then it is more likely than not to be encompassed within the penumbras of field of play. Okay, so that's the first case I wanted to look at. Now I want to turn to a second case that in the award very much echoes the logic of SovSec. But I want to use it to illustrate what I think are some of the limitations and the problems with trying to take this logic too far. This case is Simon Delestre, Delestre versus the FEI, the Equestrian Federation. And one of the reasons I chose this case is I worked as counsel on it, and I think it was an extremely interesting case. And we appealed it before CAS, and it was going to go towards an award. And for various reasons, the matter did not proceed to a hearing. And I think that's unfortunate because the case raises in my mind some very important questions that I haven't seen adequately addressed in other cases. But let me give you the brief background here, which again is quite straightforward. We're in the quarterfinals of the 2025 Global Champions playoffs in Prague, and the French rider, Delestre, completed a clear round in a show jumping competition. So no member of the ground jury intervened, no penalties were assessed, the round was clean. Two other teams completed the rounds, the competition concluded, results were published. So we knew the final rankings of the teams. After the event had concluded and the results were published, a member of another team went to the judges and claimed that Delestre's helmet harness, the latch that keeps the helmet attached to the head, had become unfastened during the round, and this would be potentially a violation. Following a review of the video, the ground jury concluded that the helmet retention harness had become unfastened. Pursuant then to the rules, they imposed a penalty, and that penalty had the effect of dropping the team several points and removing them from the competition. This was appealed to the FEI tribunal, and the FEI, in its filing, argued that this was a classic field of play decision, and the tribunal had no authority to challenge it. Right? There was no basis for challenging this field of play, and the tribunal agreed. Right? They classified this as a field of play decision. They quoted language from the Jordan Childs case, which we'll mention in a moment, which provided that video recordings that are part of a review process are encompassed by the field of play and not open to review, and they closed the case. And the logic that was at work here is very similar to that in SovSec. Right? It's encompassing a broad view of what field of play is. And so the use of something like, in this case, video review, even when done ex post, even when done after the competition, even as in this case, when done after the results were published, still constitutes part of that original judgment, right? So we're creating an elongated temporality by which the field of play is viewed. Right? And on kind of initial glance, this seems like a case where that principle might well apply following Savsek. But what I want to point out are a couple of what I think are quite significant issues that to some extent are particular to this case, but which have analogs in other possible disputes that I think should caution us in thinking that we can too facilely say that video review as such or additional layers of review procedures simply are an extension in time and in nature to that classic field of play judgment. Let me point out what I think these issues are. One is the rules of the FEI authorize the use of video review. So that is not in question. But they authorize use of video review to review a decision. One question I might put on the table, and I think it's not a mere theoretical one, is can you review, in this case, the performance on the horse jumping round when there was no decision, right? A decision was not being reviewed. This was using video to make a de novo judgment that had not been noticed before. That this was not interrogating a question in the judge's mind. It was essentially rerunning the competition with fresh eyes to assess whether something unnoticed before should now form the basis for a penalty. And I think there's something potentially problematic about that. In particular, should rules of federations that grant the authority to use video review, absent clear guidelines for when and how that video can be used, create the pretext for an open-ended de novo revision of all aspects of an event. And I think that's arguably a quite problematic proposition. And there's some authority for that. I mean, a case you might look at to explore this further, and one which has received some amount of attention, is from 2018, and it's the Japan Triathlon Union versus the International Triathlon Union, which I would read as standing for the proposition that field of play decisions permit a full review when, and quoting here from the case, they occur immediately after or proximate to the competition. And so this question of what is proximate is something we need to wrestle with and not take for granted. A second issue that I think is quite problematic about the Delestrae decision, and one which materially distinguishes it in my mind from the Savsek case, is that here there were rules governing the review. Yes, there was the rule permitting review as such, but it came with rules and conditions. First of all, it was subject to a juridical standard. So the rule permitted video review where there was, quote, irrefutable evidence that the original ruling or decision was incorrect. Now, we could argue what that should prompt a jury to do, but when there is a standard, right, the imposition of a legal standard, that seems to create the kind of context within which the CAS has been willing to say that is a legal judgment subject to review, not a discretionary field of play determination. And it would seem, among other things, to perhaps require the jury to provide some explanation for how that standard has or has not been met under the facts. There's one other rule at issue, which is that the particular issue concerning the harness, the helmet harness, is that it is only a penalty if the rider does not stop if it is when it is unsafe to do so. In other words, if the strap becomes unfastened, it is not a penalty for the rider to not stop if doing so would be unsafe. And so again, this seems to create a standard, a rule, which requires both some interrogation by the jury, some articulation of the rationale for the judgment by the jury, and arguably the creation of a legal standard that, again, is precisely of the nature that Cass has said is a legal standard, not a discretionary judgment. Okay? So these two cases I've paired because on one hand, they allow us to see how technology, variegated processes are extending field of play, but I don't want us to too easily slide into the belief that we can do so without nuance and complication. Let me turn to the third case, which is the Jordan Childs case. I'm sure you're all familiar with this. Let me just very briefly mention the facts, right? This is from the 2024 Olympics, and it's a very important case for our purposes because it adds another layer to examining this boundary between field of play decisions on one hand and reviewable rule-bound processes on the other. Okay, so the facts are quite well known. Jordan Childs completed her exercise in the finals of the women's floor exercise, and she received a score of 13.6, which placed her in fifth place behind two Romanian gymnasts, Ana Barbasou and Sabrina Mansea Voinea. Now, Childs' coach, immediately upon the completion of the round, submitted an inquiry challenging the difficulty score, the difficulty value that had been assigned to her routine. And under the rules, the coach can do this, but they must submit the challenge within 1 minute of the posting of the score. The jury accepted the inquiry. They reassessed the element. They increased Childs' difficulty score, and this elevated her into third place, into the bronze medal position. Immediately thereafter, a challenge was brought before the CAS ad hoc provision by the Romanian Gymnastics Federation. There were two separate matters that were ultimately consolidated into a single award. I think Amelia just posted that award in the chat. Let me run through the two claims because they both cover something very important to our conversation. So the first claim concerned Voinea. During her routine, the judges had imposed a 0.1 penalty after concluding that her foot had stepped out of bounds on the competition boundary. Later video footage appeared to show that she had not, in fact, done so. And so she argued that the deduction had been wrongfully imposed, it should be removed, her score should be increased, and if so, her revised score would place her and not Childs in the bronze medal position. The second claim concerned Barbasou, and this one directly involved what happened with Jordan Childs' routine. The focus of Barbasou's claim was not that Childs did or did not deserve the additional 1/10 in difficulty. The claim was rather that the inquiry made by her coach had been submitted late, outside that 1 minute window. If so, that would make, so it was argued, the inquiry invalid, thereby negating the authority of the jury to review and to therefore increase her score and therefore necessarily removing her from the bronze medal position. So let's run through these two in turn. The first claim was treated by the CAS panel as a classic field of play decision. Competition officials observed the performance, they applied the rules, they exercised the judgment. Whether it was right or wrong, it is not within the purview of CAS to reassess that determination. So sporting judgments made by officials remain insulated from review. There were a couple of other issues in the argument, but in essence, CAS treated it as a classic field of play case. For the second claim, the question, again, was about these procedural mechanisms. And after examining the evidence, CAS concluded that the inquiry had, in fact, been recorded at 1 minute and 4 seconds after the publication of the score. And this was a point, importantly, that was not disputed by any of the parties, including Childs. So data had been recovered from the timekeeping mechanism showing that the claim was recorded at 1 minute and 4 seconds. So this was not disputed. Now, what Childs tried to argue was that this nevertheless fell within the field of play. The panel rejected this. They argued that they were not being asked to substitute their judgment for that of the referee. They were asked to determine whether the panel had the legal authority to reconsider the score. And they said, given this information regarding the failure of the legal norm, the 1 minute limit, that authority did not exist, thereby invalidating the assessment, the reassessment. Okay. So in these two cases, we see very clearly this distinction we've been talking about. On one hand, classic field of play. It's about deference to the decisions and the determinations of officials. On the other hand, a reviewable procedural or legal or rule-bound norm, which CAS holds can be subject to review. Okay? So this, I think, for us is the most important distinction to keep in mind, because this award very clearly shows how in much of modern field of play litigation, the concerns are increasingly about this legal architecture around sporting judgments. Okay. In the interest of time, I won't get into what has happened subsequently with the Swiss Federal Tribunal. It's not directly relevant to the field of play issue, but this drama has not ended. But let me leave the discussion of Childs to that and move on briefly to the final two cases I want to discuss. And I want to mention these because they raise a somewhat different issue concerning whether and when governing bodies can replace a sporting outcome. And so that's the question I want to look at. And the two cases that I would like us to consider, one is the case involving the Kyiv Capitals versus the Ice Hockey Federation of Ukraine. A case that has gotten a little bit of attention, but is I think of relative importance in the broader scheme of things. But Kyiv Capitals versus Ice Hockey Federation of Ukraine, and then we'll talk lastly about the AFCON final case that is still in process and awaiting a judgment from the CAS. So in the Kyiv Capitals case. Let me try to summarize quickly what happened. There was a hockey match between the Kyiv Capitals and another club, and the club from Kyiv became dissatisfied with what they perceived to be officiating that was biased. Too many penalties being called against them, not enough against the other club. Eventually, they left the ice in protest before the match had concluded. Because of this, the federation's disciplinary bodies imposed a sanction on the club that included a forfeiture of the match. What is important is that the officials had not done so. And so they had, pursuant to the rules, the authority to impose a forfeiture. They did not. But it was later done by the disciplinary body and affirmed by the appellate body. When this case eventually made its way to the CAS, the Kyiv Capitals advanced two arguments. First, they argued that the referees applied the wrong rule in dealing with the club leaving the ice. There are two rules in the federations, in the rules governing the federation. One governs when a team refuses to take the ice, right, to begin a match. One concerns situations in which a team refuses to continue playing after a match has begun. And the Capitals argued that they applied the rule concerning failing to take the ice, not the rule concerning failure to return to the ice. The arbitrator agreed. So the arbitrator said, you're right about this. But, and this is the important point for our purposes, she concluded that this was immaterial to the outcome. In effect, what she said was this was a field of play judgment that is not subject to review, and also by extension does not bear on the larger question at issue, namely whether the authority was properly vested in the disciplinary body to impose a sanction and whether CAS had the authority to review that judgment. The second argument that the Kyiv Capitals advanced was that the disciplinary bodies did not have this authority. In particular, they argued that the referees had the exclusive authority to either impose a forfeiture or, as they did, to not. And that decision pursuant to the authority vested in the referees at the moment of the match is exclusive. And so the failure to impose a forfeiture then settles the matter and it's not subject to review. The sole arbitrator at the CAS rejected this argument, holding that another rule in the Federation's rule book empowered the disciplinary authorities to investigate forfeited games and to impose sanctions. In other words, the authority is not exclusive to the referees. It is also simultaneously, and one might say equally, vested in the review bodies. And so as the arbitrator read this, not only was the failure of the referees to apply the correct rule immaterial, that was lex ludica, that was field of play. The Federation's disciplinary response was done pursuant to a rule, and it was framed as a lex sportiva judgment. It was a rule that the CAS could review. Now, in reviewing it, they said it was properly exercised, and so the decision was held. But again, you can see in this case this bifurcation between field of play, reviewable, and a rule-bound process reviewable by the CAS. I just want to mention two things in closing that are interesting about this case, and then we'll transition to the final matter and wrap things up. A very interesting thing that the arbitrator mentioned in this case. Let me see if I can find the quote here. Yeah, so the arbitrator, while accepting that the disciplinary body had the authority to review de novo whether a forfeiture was appropriate, nevertheless wrote the following. The arbitrator has the authority to, quote, verify that a breach of the applicable rules concerning a forfeiture has been committed and that the sanction imposed corresponds to that specifically provided for that type of violation. Now, this, in my mind, is perhaps the most interesting feature of this case, because the arbitrator is arrogating to herself the prerogative to assess whether the authority being exercised by the review panel was done in conformity to the rules, but also to assess whether that authority, if properly held, was being exercised in conformity with the rules. That's taking us into new territory. And I think there are ways to square that approach with what we've seen from Savsek, Delestra, and Childs. But it does force us as well to think about new questions such as, why is this committee's review not treated as an extension of field of play? And it's one thing, and I think deeply embedded in established jurisprudence, to say that CAS has the authority to determine whether the rules vest this review tribunal, this disciplinary body, with the authority to issue a forfeiture. It's another to say that CAS has the authority to then assess the application of those rules to the facts. Again, I think there are ways to distinguish these cases and to maintain a thread of coherence and conformity among them. But this introduction of a new element does add another layer of complexity and force us to again see that extending field of play in these ways is far from a straightforward or univocal process. Okay, the last case, and one that I think Njeri will very much want to opine on when we all come together. But this is the dispute that arose out of the finals of the 2025 Africa Cup of Nations final. So January of 2026 in Rabat, a match between Morocco and Senegal. The match descended into an extended period of chaos after Morocco was awarded a penalty following a video review. And Senegal, who had had an earlier goal disallowed, reacted angrily and eventually left the field and remained off the field for an extended period of time. Eventually, the players returned to the field. Morocco took the penalty kick. They missed. And Senegal ultimately won the match 1-0 in extra time. So Senegal was recognized as the champion, trophy was presented, and the competition appeared to have concluded. However, Morocco challenged the validity of the result, arguing that Senegal's temporary withdrawal from the field should have triggered regulations which provide that a team leaving the field before the completion of a match forfeits the match. And nearly 2 months later, the CAF Appeal Board accepted this argument, held that Senegal had forfeited the match by operation of Articles 82 and 84 in the regulations, and they replaced the 1-0 result in favor of Senegal with a 3-0 victory for Morocco. So this matter has been appealed before CAS. Others of you may know more about where things are, but to my understanding, the briefs have been filed, the panel has been assembled, and word on the street is an award might be expected in September or October. But in terms of the relevance of this case for our question about field of play, it does raise some new and interesting questions. Right? So the controversy, again, to kind of bring this back to our subject heading, the controversy concerns whether a post-competition governance body possesses authority to replace a sporting result produced through a completed match. Now, if you really want to get into the weeds of the AFCON regulations, people who work in football and understand this far more than I could advance nuanced arguments over whether the appeals body within CAF even has the authority as such to review matters arising out of the field of play. And I think there's an interesting legal question there. But we can look at this in a much simpler point of tension. We know that under Article 2 of the AFCON regulations, there is, yes, a rule that says a team that refuses to return to the field of play is deemed to have lost the match. But the counterpoint is that Article 43.7 of the same set of rules provides that the decision taken by a referee, and I'll quote here from the rules, on the ground during the match on matters of fact shall not be subject to protests in any case. So I think we should be somewhat careful about viewing this as a strict field of play case in a narrow sense. It is, among other things, about these dueling legal authorities. On one hand, Article 43.7, that decisions made by the referee on the grounds are not subject to protest in any case, counterposed against Article 82 and IFAB Law 5 concerning a principle that a team which leaves the field of play is deemed to have forfeited. Now, I think what you can start to see are echoes of the recent World Cup controversy involving the American player, Balogun. And here, right, I mean, a lot of the controversy was over the primacy of the automatic nature of the red card. Right? So the relevant provision in the disciplinary code provides that upon issuance of a red card, suspension is implemented. And if that suspension is deemed to be automatic and the automatic nature of a red card is primary, then I think, according to most interpreters, it should override any countervailing potential authority to review the decision. And I think that same kind of logic might well apply here, that even if one were to posit, and again, I think this is itself a complicated legal question that I'm not sure I feel comfortable opining on, but even if one were to determine that the CAF Appeals Board had some jurisdiction to review matters, that the primacy of the field of play principle encapsulated in this rule concerning the referees should trump it. Okay. Last point I want to make about the AFCON case is to look at how it differs from the Keefe Capitals case. Because both of them, right, on some level involve this question of dueling sites of authority between referees and other bodies vested with review authority within the federation. But there's a key distinction. And that is that the institutional process in the Keefe Capitals case, and this again is what the CAS arbitrator focused on, was explicitly delimited in the rules. Right? There was explicit authorization to impose a penalty of forfeiture. So there may have been dueling loci of authority, but there was no doubt that the authority to issue this specific penalty existed. We don't have anything comparable in the AFCON case, which at best seems to be operating in something of a liminal legal space concerning authority that the appellate body would have. So I've probably already overrun my time. Let me take just 2 minutes and kind of summarize what I think are some key takeaways, and then I would love to have a conversation. Field of play is evolving, right? The core doctrine is settled, but on the peripheries, at least, there are new and I think constantly emerging questions that often involve, I've proposed, these layered review processes. And we need to think about how and when and to what extent we can extend the core logic of the classic field of play doctrine to new scenarios. The legal questions are also changing. So classically, the question was, who made the decision? If it was a referee, a judge, an official, it was field of play. But the CAS and other tribunals are now explicitly or implicitly asking quite different questions. They're asking, what was the purpose or what was the function of a decision-making process? So not who made the decision, but what was the nature of the process being performed? What is the relationship between the decision and the event? And we can think about that in terms of time. How much time has elapsed? How tight is the nexus between the event and the review? What is the relationship in terms of process? What is the relationship in terms of decision maker? And who has authority to review? And on what basis? And according to what authority? And is that authority subject to rules, limitations, protocols? Last two things. I think the most complicated disputes, as I've mentioned, concern this interplay around institutional authority, governance, and procedure, and in particular, the need to distinguish between sporting judgments and legal questions that arise out of rules and processes. And the very last point I want to highlight, I wish we had more time to explore this because I think it's a very interesting phenomenon, is that governing bodies are becoming attentive to the problems we're discussing today. And one way that they are attempting to address it is through legislation. So field of play has emerged, exclusively almost, as a juridical or arbitral doctrine. But what we are seeing today, the World Gymnastics has done this, the FEI rule that I mentioned has done this. Some of the FIFA rules do this, is they explicitly address field of play in their rules. They try, in other words, to create definitive norms that will say what is field of play and what is not, what is reviewable by appellate tribunals and what is not. World Gymnastics, and if you want to take a look at this, it's very interesting. In their 2026 technical regulations, they went so far as to say that decisions involving inquiry, so the issue involving the inquiry made by Jordan Childs' coach, constitute, quote, let me read to you from the rule, final field of play decisions that cannot be challenged internally or externally, including appeals to the Court of Arbitration for Sport, which has no jurisdiction over any challenge. I mean, that's pretty bold, right? To attempt to deal with the problem by legislating CAS out of jurisdiction. Now, I think this is jurisprudentially problematic. I mean, the principle of competence would seem to say that CAS gets to determine when it has jurisdiction. But the fact that World Gymnastics and other federations are doing this is both an interesting development that we need to pay attention to, but it's also a sign of just how complicated this landscape has become. And to return in concluding to the theme that I mentioned, we confront this paradox that federations have tried to create more fair, more rule-bound, more determined outcomes through additional processes, through the use of review, through the use of technology. But this has generated, in turn, more litigation and more space for challenges. Recognizing that paradox, that tension, one response it seems that is now occurring is attempts to define the boundaries of field of play itself. So let me conclude on that point, and thank you for your very kind indulgence and patience. And I look forward to exploring things further with everyone.
I don't even think I can find my voice. I warned you in advance that the onion shall be peeled, and I'm sure many of you are now having their eyes watering because of that sting from the onion peel. Thank you, Zachary. I don't think we could have had a better person. And please allow me not to try to recap what has been said because of limitations of time. I do believe that Zachary was very clear in the distinctions that he has set out and the nuances in all the sports and the extensions of the field of play. Zachary, I wish it was possible to give you the claps, but those who can, please give him his flowers while he's still with us on the line. May I invite a few questions, and maybe Emilia, you can have a look at those that have been posted on the chat. And I know people may want me to comment, but that will be the last item I will try to do. So questions, please, for maybe another 10 minutes or so.
Njeri, we have one from Fatma. I don't know if Zachary would be happy to answer this, but it says, from your experience, how should sports governing bodies address Argentina's conduct during the FIFA World Cup, particularly following the incidents that occurred in the final match against Spain? So I have a question, and so that's one question. The second one is just, and I'm interested in the reflection from both of you on this gradual incursion of politics into sports and political power appearing to influence otherwise decisions that should, overreach, actually. Maybe I should just stop there and say overreach. What do you see? Do you think that this would be restricted to the US because of the behavior that they currently have? Or do you think that this might actually expand? I mean, there's lots of money involved. There are lots of interest. How do you see politics impacting on this in this area? So those are two questions. Or somebody has supported the question about Argentina and Spain. So we might need to get a referendum going. But those are the two questions for now.
I'm afraid I missed the most important word in Fatma's question, which was what came just before, I believe, conduct.
Okay, so she says, how should sports governing bodies address Argentina's conduct?
Oh, Argentina, sorry. Oh, Argentina.
Yeah,
Gotcha.
Argentina's conduct during the finals. Yeah.
Well,
during their final match with Spain.
This is not merely a strategic deflection, because I'm not sure I have anything profound to say, but it's a truthful statement, which is that even though I am currently in Spain and was in Spain during the final, I didn't actually watch it. So I've only seen still videos of the throat attack by Argentina. I guess let me try to pull both of these questions together, because I think at core they both raise a similar issue, right? I mean, on one hand, Trump's intervention. On the other, what I understand, I've not followed this closely. I view it the prerogative of being on holiday, but my understanding from a quick perusal of the news is that no penalty will be given to the Argentinian player. I believe that's the case. So if the red card that was issued has been withdrawn or no red card was given, I think that's the case. We might even add a third case study here, which was in Argentina's previous match, the issue that arose with the banner concerning the Falklands Islands. I think all three of these issues have, among other things, running through them, the question of rule-boundedness. And one concern I would have, as a lawyer, as someone who's concerned about the legitimacy of these enterprises, is that once you interject the appearance and the reality of capriciousness with regards to the application of laws, that becomes a very difficult thing to recover. And part of what we talked about today was to explore, when do rules matter? What are rules and what are discretionary? And I think a very good case can be made that in all three of these issues, the red card given to the American player, the red card given to the Argentinian player, and how the FIFA, or for that matter, the IOC, has typically dealt with forms of what are deemed impermissible political protest, established pretty clear precedents. And in none of these cases were those precedents followed. And that would seem to invite a lot of space for mischief and a lot of space for lawlessness. And even if those repercussions can be contained, we've undermined even further the very legitimacy of processes. And I think that's dangerous. So it's one thing to have very nuanced arguments, as we were trying to do today, about when are rules in place that need to be assessed. It's another to say we have a very clear rule, but we're just going to ignore it. And I think that's very worrying, especially when, quite possibly, as in all three of these cases, the decisions reflected political or other external pressures. We should be worried about that.
Thank you very much, Zachary. Njeri, that's it. I don't know if anybody else has a question. Mark, please.
Thank you so much, both professors. Thank you so much, Senior Counsel, for the excellent moderation. I just had a quick question in relation to the finality as it relates to these arbitral proceedings or proceedings before the CAS. Obviously, when you've given examples of quite a few cases, and as you said, you've looked through a number of cases. As it relates to a field of play, and they seem to be very I don't know if tense is the right word, one way or the other. So I just wanted to find out, once the awards are issued, do the parties tend to abide or be content with what's been issued by the tribunals, or do we tend to see some of the challenges? I understand there could be a limited process to challenge, or do we tend to see the utilization of those limited uses of challenging?
No, that's a good question, Mark. And others can chime in. I mean, without having investigated this systematically, I think it's fair to say that awards are generally followed. I would probably distinguish between following and accepting. If by the latter we mean ceasing to express in ways public and otherwise disagreement with the determination. But I do think, in sport as in arbitration more generally, compliance tends to be quite high. I mean, higher in sport than in commercial matters for lots of reasons. But there's another interesting point, and maybe I can use this to give a 30-second update on the Jordan Childs case, because this is a great illustration of your question. So we ended our discussion of that case with the Cass Award, which said 1 minute and 4 seconds. The appeal was unlawful, as it were. Therefore, Childs's original score needs to be reinstated. Now, what happened is some days after that award was issued, the U.S. Gymnastics Federation came into the possession of video evidence, actually from a Netflix documentary that was being filmed at the competition, that managed to capture both what was happening in real time and audio that was being communicated by her coach to the person to whom the inquiry has to be made. And it established without doubt that the appeal was made at the 47-second mark or something, clearly under the 1 minute mark. So now they had evidence that, in fact, the entire premise for Cass's award was misguided. They went back to the Cass, seeking, in effect, to have the matter reopened on the grounds of new evidence. And I believe it wasn't a formal award, but the president of the tribunal stated that there is no authority under the Cass rules to revise awards on the basis of new evidence. So in terms of the internal dispute process culminating with Cass, the matter was closed, even though, the U.S. had been extremely vocal in criticizing it per your question. But just to wrap the story up, there is, as many of you no doubt know, because the Cass is subject to Swiss law, there's a right to appeal under Swiss law to the Swiss Federal Tribunal, essentially the Supreme Court in Switzerland. And the U.S. Equestrian Federation did this with Jordan Childs. They presented the evidence, and the Swiss Federal Tribunal, on the basis of this, they didn't rule on they didn't rule on the validity of the evidence as such, but on the basis of its strength, annulled Cass's award and reverted the matter to Cass to issue, to have a new hearing. So it's entirely possible that 6 months, now we're what? We're 2 years out already. That sometime in the next, 3 months, 6 months, I'm not sure where this process now is, there could be a new Cass award, which has the awkward conclusion of revising the standings and giving back the bronze medal to Jordan Childs. This is extremely rare. I mean, the number of times when the Swiss Federal Tribunal will intervene in these ways, very rare, but it does. And it often happens in some of these high profile cases. And it's a good reminder that the system internal to sport is not entirely insulated from review.
Thank you so much.
Thanks, Mark.
Thank you. So, Njeri, I think we can now wrap things up. I know that this is very, very interesting topic, but I think if you have do you want to add anything else before we say our huge thank yous?
I'll be guilty because the AFCON first instance matter was before me. I think we need to look at the rules of each federation, and I do agree with the distinction that Zachary has drawn, that the rules of each federation really will make the difference, because the rules of CAF, which mirror or adopt the rules of FIFA, for me it was very clear that the referee's decisions are insulated, especially the decision on field of play, the technical rules. He made a determination that it was safe to continue. The problem was that the basis of the claim was Rule 83, 82, and 84. Yet 84 can only operate if both 83, 82, and 83 are breached. And the referee did not see in his final report, for him it was a temporary removal from the field of play without his permission, he says so. But eventually he allowed play, and in fact he says the delay was more caused by the security reasons for what was happening in the terraces, in this fans, supporters area, where the supporters had engaged security in some fight. It could have resumed earlier. So, and wherever there was a small difference between the referee's decision and the match commissar's decision, the referee's decision under football regulations takes precedence, or what the referee has recorded is what is superior to any other official if there is a conflict. For me, it was very clear that unless the departure from the field of play culminated in a total abandonment, the referee was right to have the result of the match stays. It was as simple as that to me. So I'll wait to see the correction, and perhaps Zachary should be in the arguments with this very nice field of play cases that he has. But also, I think on the last issue, the political statements, I am surprised that a red card was overturned by, I want to imagine that there was a disciplinary process that was raised. If there wasn't, then I'm totally appalled. But I haven't gotten into the issues and to determine how the red card was overturned. I wouldn't do it if I was sitting in a disciplinary panel for FIFA. I wouldn't do it. And if they did it, then I'm in shock. The political statements, of course, I wish to refer those of you who will have the time. There is a decision I made before I left FINA on a Russian one. I forget the name right off my head, but he went into some celebrations, donning and lifting the flag in support of Russia's invasion of Ukraine. And it was brought before us, and we gave him a 1-year ban, and he missed a world championship, I think 2023, and I think it also affected his qualifications for 2024 Olympics. And it's very clear for me the burden rests with the secretariat child with bringing up the disciplinary process, because what happened with Argentina is what would be referred in FIFA's own regulations as bringing the sport into disrepute. It's as simple as that, and they have the evidence. It's all over social media. It was live on World TV. So let me leave it at that.
Thank you so very much.
Interested, you can check on the matter of FINA against a Russian. It was the top Russian swimmer at the time.
Yeah.
Thank you.
Okay. Great. Thank you so very much. I think we're leaving most of you with watch this space, because we're waiting to hear back from Cass on the update on Jordan Charles. And we need to also appreciate that lots of money is involved. It's usually where you smell the money, you follow the money. And I haven't said anything regarding red card and anything, but Infantino had said that it was a decision that was made objectively. So we'll wait to see whether that will be challenged and what other decisions will be made. I think that what I think is that two things actually. The first one is with the recording, we may see a few, maybe some more developments and the distinction that Zachary was drawing. I think that will become more important. The other one is cautionary. This whole with deep fake and changes in video recordings of sports and who was there, who was not. It might also, begin to raise some concerns. And so we might have conflicting video recordings and Netflix documentaries that might then confuse us. And so watch this space. What's left is a huge, massive thank you. I wasn't expecting anything less. So Zachary, thank you so very, very much. And it's nice that you're in Spain. No, you have a last minute comment or question.
Yes, thank you so much. I wasn't to ask my question again, but I think you just said something last that actually touched me, and I said, look, let me prompt that about the videos coming and circulating here and there. I mean, today we are being challenged with issues of AI, where people can actually manipulate things so well, and you may not. So if we are going to rely on videos and someone also brings something and it looks different, or if you are confronted with 2 different videos or 3 different videos of the same event, how do we deal with such a thing? And using the videos as evidence to actually help in guiding or in making a decision in the end. But before I conclude, I want to thank the Professor Zachary for his wonderful, exciting presentation and the illustration he gave. Thank you so much, Prof. Thank you.
Thank you so very much. Njeri and Zachary, do you guys want to make any comment? Maybe we should rely on whatever recording that FIFA has or the sporting, and then every other person's recording is subject.
I think ultimately we have to distinguish and say maybe for the former, like normally FIFA or CAF would give a broadcast rights.
Yes,
it's safer than because all of us go with our cameras and we take different angles and we can even manipulate it as Noha said, and yeah, all those things can happen. But
okay.
I think I would stick to as official.
The official, yeah. Okay.
Broadcast.
Good.
Yeah.
Very good. So watch this space. I think for our young practitioners on the call, what it means is that there's future work in this area. And one of the things we're trying to do is really bring various aspects of sports law and dispute resolution to people's attention, so to open up the area for study and practice. And so connect via LinkedIn with Prof and Njeri. And if you have any further questions, counsel for Prof and Njeri, they would be willing to answer your questions. Thank you so very much. Enjoy the summer break, and this is our last webinar for this academic year. And
Amelia, it is Kenya's winter.
Okay, enjoy the cold. In Nigeria, it is raining. So enjoy the cold, the wet weather, and for us, the heat. Whichever one you are enjoying, please go ahead and enjoy. In September, we'll be back. And just to put people on notice, we would have a change of leadership with our management committee. So I will be handing over to my colleague, Professor Lau, who will then take over as director of our center, which is great news for us all. And then the rest of us, we carry on. And of course, Mark has also joined our management committee. He's one of our lecturers here at SOAS, so that's great. Most likely, he will be the one dealing with webinars and our programs, but I will still be on board. But Very grateful for your support. Thank you so very much. Zachary, enjoy Spain. And then
Thank
we'll
you,
see you
Amelia.
soon.
Thank you, and Jerry.
Jerry, I'm seeing you
Thank you.
soon. So
Thank you.
Thanks, everyone,
Yeah,
for
welcome
your
to
questions.
Nairobi.
I will. Thank you. Bye,
Okay.
everybody.
See you in
Thank
Nairobi.
you. Thanks. Bye.
Bye-bye.